Hey, good evening, YouTube. We continue on the Executor and Administrator Guide on page 52. Go right on in. Whenever a absent or non-resident executor or administrator shall have been duly served with a citation to account and shall without reasonable cause neglect or refuse to appear in pursuance thereof, the surrogate may, in his discretion, revoke the letters to such executor or administrator. S. L. 1846, Chapter 288. Surrogate. Uh-huh. The surrogate of the County of New York may revoke the letters of the executive administrator or collector of the testamentary trustee or guardian upon their own application for good cause shown, and a notice to the person interest, and may make such terms and conditions for the security of the estate as in his judgment are required. After such revocation, the surrogate may issue letters of administration, letters with the will annex, or of collection, or appoint a successor to such trustee or guardians. S.L. 1870, Chapter 359, 47, 2 R.S. 79, 3 R.S. 5th Edition 165. All sales made in good faith and all lawful acts done either by administrators before notice of a will or by executors or administrators who may be removed or superseded or who may become incapable shall remain valid and shall not be impeached on any will afterwards appearing or by any subsequent revocation or superseding of the authority of such executors or administrators. Of the duties and executors and administrators in regard to the inventory and the rights of the widow and minor children. The duty of executors and administrators to take an inventory, although too often neglected, is highly important and imperative directed by statute. There are very few cases in which it is the consistent with the most common prudence to neglect taking an inventory. It may not be necessary in all cases to file it. Neglected taking an inventory may be necessary in all cases. 2 John chapter R 62. Surrogate granting letters shall, upon the application of any executor or administrators, appoint two disinterest appraisers as often as occasions may require to estimate or appraise the property of the deceased person. 2 RS 82, 3 RS 5th edition 168. See order in appendix. The appointment is made by the surrogate and he usually consults the desire of parties as to whom to appoint. The duty of the appraisers being to fix a value to charge the executive administrator as between him and the next in kin, legatees, etc. It is a very improper rule to appoint only those who could act as jurors in the trial at law in which any of those parties may be interested. Two or more inventories may be made if necessary. 2 RS 82, 3 RS 5th edition 169. A notice of such appraisement shall be served 5 days previous thereto on the legatees and next of kin residing in the county where such property shall be, and it shall be also be posted for the same time in 3 of the most public places of town. See form notice appendix. And it is very proper, although not required by law, to attach proof of such service in posting to the inventory field with the surrogate. The appraisers shall, before proceeding to execute their duties, take and subscribe an oath, see Form Inventory Appendix, to truly, honestly, and impartially appraise the personal property which shall be exhibited to them. After the first meeting, they may adjourn from time to time as may be necessary, it being the duty of the executor or administrator to exhibit the property to the appraisers. He may well spend some time in arranging it in classes before meeting to facilitate their labor, as well as to learn the extent of the details of the property for himself. Thus, he may arrange the notes in one class, bonds and mortgages in another, forming implement stock of farms, furniture in other classes. Duty is the regard of the inventory. If the executor or administrator has reason to suppose that any person has goods of the deceased and proposes to detain them, he may make an application by petition under oath, stating the facts to the surrogate, who will issue a subpoena to the person whose hands the goods are supposed to be, to appear be examined before him. SL 1870, Chapter 394. The appraiser shall, in the presence of such of the next in kin, legatees, or creditors in the testator, or intestate, as shall intend, proceed to estimate and appraise the property, which shall be exhibited to them, and shall set down each article separately, with the value thereof in dollars and cents distinctly in figures opposed to the articles respectively. See the Form Inventory Appendix. 6. The following property shall be deemed assets and shall go to the executors and administrators to be applied and distributed as part of the personal estate of their testator or intestate, and shall be included in the inventory thereof. Leases for years, lands held by the deceased from year to year, and estate held by him for the life of another. The interest which may remain in the deceased at the time of death, in return for years after the expiration of any estate for years therein, granted by him or any other person. The interest in land divides to the executor for a term of years for the payment of debt. Things annexed to the freehold or to any building for the purpose of trade and manufacture, and not fixing to wall of the house so as to be essential to its support. Hop poles used on the land are part of the realty. 11 New York 123. Cotton machinery is personal property. 10 Bar 157. Looms in the woolen mill are personal estate. 18 New York 28. Water wheels, millstones, bolting apparatus are part of the realty. 10 page 158. Manure, not the produce of land. The accumulation of livery, stable, and personal property. 15 Wind 169. Two Hills 142. In converso, manure accumulated on the farm from the produce thereof is part of realty. The crops growing on the land of the deceased at the time of his death, that is, crops which are annually produced by cultivation and not crops, the spontaneous product of the soil, as grass and fruits. Every kind of produce raised annually by labor or cultivating, excepting grass growing and fruits not gathered. Rent reserved to the deceased, which had occurred at the time of his death. Okay, we're going to continue on next.